A federal high court in Abuja will reconvene to deliver judgment in the trial of self-styled leader of the proscribed indigenous people of Biafra, Nnamdi Kanu. Before he went on a short recess, the court found him guilty on all 7 counts of terrorism. TVC News senior reporter Celestina Iria has spent the whole day in court and now joins me. Celestina, thank you for joining us at this time.
Thank you very much. Today.
It's been a busy day for you in court, over 6 hours and 3 hours of judgment and still counting. We saw a bit of drama in the court today. Before that happened, just give us a recap as to what has, ensued in the court today.
Okay, well, finally, a case that started 10 years ago is coming to an end, and the judge in no time will deliver his sentence in the case that started in 2015, and this is 2025, over 10 years. And the case has gone through 2 judges. First, it went through Justice Nnamdi, and at that time in 2015, when Mr. Nnamdi Kanu was arrested, he was charged alongside 4 other defendants. And during the course of the proceedings, he was granted bail. But according to what he said, there was an attack, a military invasion on his hometown in Abia State, which made him have to flee for his life, and he went outside the country. The other defendants that were charged with him, the trial had to continue, and the court also had to try him in absentia. But in 2021, he was rearrested from Kenya and brought to Nigeria, and that matter continued again before Justice Nnamdi. So, but during the course of that proceedings, Mr. Nnamdi challenged the charges against him. First, it was 4 counts on treasonable felony. Later became 15 counts amended charge on terrorism and treasonable felony. Mr. Nnamdi challenged these charges, and the court struck out 8 out of the 15 counts, leaving 7 counts. Still, he wasn't very happy with the remaining counts. He insisted that the court should have checked the entire charge against him. So he went to the Court of Appeal, and the Court of Appeal graciously granted Mr. Kanu his relief and struck out the entire charge and asked that he should be sent home. That due to Nigeria, that in fact made the whole proceeding, the federal government informed and prayed the court to stay execution of that judgment. So they went up to the Court of Appeal, Supreme Court, I beg your pardon, and the Apex Court did not, in fact, agree with the Court of Appeal. The Apex Court has said that the fact that Mr. Kanu was extraordinarily renditioned, or the manner at which he was brought back to the country was in violation of the Kenyan extradition laws. He should have come by way of enforcement of his fundamental human rights, stating that his rights was violated. But that does not mean that the remaining 7 counts against him, he would not answer for those charges. So the court ordered that he goes back to the Federal High Court to answer to the remaining 7 count charges against him. So now we all came back to the Federal High Court for the commencement of the trial in the 7 count charge. But during that process, success was not really achieved because it came from one application to another. As a matter of fact, Justice Nnamdi ruled on over 22 applications of motions. First, brought by the prosecution, and also most of them brought by Mr. Kanu, alleging his ill treatment at the facility of the DSS, how he didn't have access to lawyers, how his head was deteriorating, how he was kept in a cubicle, a 2-by-2 cell with no light. So basically, he was asking the court to intervene, and also how he didn't have enough time to consult with his lawyers. According to him, anytime his lawyers came to the facility of the DSS, to talk to him and strategize for his trial, they eavesdrop on their conversation. But the time they eavesdrop on their conversation, when they come to court, their strategy will not work because the DSL just being there. It got to a point where Mr. Kanu feel that he could get justice if the case is being decided by her. So
that's our senior reporter who has been monitoring The court's process the judgment, where court has gone on recess and is expected to reconvene at 3:50 p.m. for judgment on Nnamdi Kanu's case. It's been a busy day in court. Celestina, I'm hoping you can hear me at the moment. Can you continue what you were saying?
Okay, so as I mentioned, when he came before Justice Montishon, the first thing Mr. Kanu did was to apologize to the courts. He apologized to the courts. He also apologized for making the Montishon to ensure that they start on a very clean slate and clean note. So the judge said that whatever happened in his brother courts is none of his business. He will decide the case as it all should be, without sentiment of fear or favor, and to be done in accordance with the law. So the case commenced, the prosecution opened their case, and they started calling witnesses. The prosecution called 5 witnesses who came to tender evidences, and most of the evidence were video evidences, which was played in court on how Mr. Kanu called for violence, inciting violence, acts during the NSAS protest, and also during calling for sit at home, and also calling that bombs be made by engineering graduates and chemistry graduates. So all this evidence, the operatives of the DSS, they all gave evidences which were tendered and accepted in court. But his lawyers said that
Please, Supreme Court here. Hold on a second. I said, hold on. May you please, your lordship? Please. May I refer the lordship to section 266 of AGJA? It's not a court of law. What you're doing is not law. Please. You don't know the law. Please. Show me. Please. I said, show me. When you have the right to waive my right to come and address. Show me. What the Constitution says. Show me. Well, I will rise and come back. You cannot show me. Can you please take him out? I'll come back. I rise. I'll come back in 5 minutes.
All right, Celestina, I'm not letting you go, but just before we continue the conversation of what happened in the court today, let's remind ourselves about what the judge said earlier in court.
Defendants have always claimed to be a freedom fighter. He is only seeking justice for his people. Indeed, this is known in law as the right to self-determination. The right to self-determination is a political right recognized in several international instruments. Article 1 of the International Convention on Civil and Political Rights, 1966, provides, and I quote, all people have the right of self-determination. By virtue of that right, they freely determine their political status and freely pursue their economic, social, and cultural developments, unquote. The right to self-determination also entails the right of a group of people to form their political entity or their own governments. Article 20 of the African Charter on Women and People's Rights also provides, and I quote, all people shall have the right to existence. They shall have the unquestionable and inalienable right to self-determination. They shall freely determine their political status and shall pursue their economic and social development according to the policy they have freely chosen. 2. Colonized or oppressed people shall have the right to free themselves from the bond of domination by resorting to any means recognized by the international community. 3. All people shall have the right to the assistance of the state parties to the present charter in their liberation struggle against foreign domination, be it political, economic, or cultural. Unquote. Nigeria has domesticated the African Charter, which is known as the African Charter on Women and People's Rights, Ratification and Enforcement Rights, which means the provision of the Charter are enforceable in Nigeria, provided they do not conflict with the clear provision of the Constitution of the Federal Republic of Nigeria 1999 as amended. Section 2(1) of the Constitution of the Federal Republic of Nigeria 1999 as amended makes it clear that Nigeria is an indivisible state, which means there is no room for divisions. The said section provides, and I quote, Nigeria is one indivisible, indissoluble sovereign state to be known by the name Federal Republic of Nigeria, unquote. This means that anyone agitating for a breakup of the Federation of Nigeria is going against the Constitution. However, any person agitating for self-determination can do so through the National Assembly seeking for amendments of the Constitution regarding the indivisibility of Nigeria and to reflect the recognition of the agitating states. It is after this that the procedure can be said to be completed, but not excluding a referendum. Any self-determination not done in accordance with the Constitution and laws of the country will be illegal.
All right, Celestina, these are some of the statements that were made in court by the judge today, following today's proceedings. But let's go back to the drama that we saw in court. Walk us through what really happened that led to, that outburst from the defendant.
Okay, well, repeatedly, Mr. Kanu has said that he's been tried by an unknown law, and the court has no jurisdiction that just should show him what law he's being tried. And the court has failed to obey the judgment of the Supreme Court, which said that he ought not to be tried. As a matter of fact, that was the Court of Appeal that said that. The Supreme Court did not agree with the Court of Appeal. But he insisted that the law that which he's been tried is as has been repealed, which is the Terrorism Prevention Act of 2013. We recall that he was first time in 2015, and the Act of 2013 was already in existence before 2015. But when they amended the Act, there's a provision in those acts that always states that the previous Act, any activity or court case being carried out under the previous Act continues, and it will seem as though the previous Act was not appealed. So I don't think Mr. Kanu was aware of this provision, but he kept insisting that this is 2022, that he's been tried rather under 2013 Act. But the court made it clear in his judgment that that is not the case. So Mr. Kanu had insisted that he cannot be tried, he cannot be jailed, as the motor does not know the law. As a matter of fact, he was captured on camera on live transmission before the court had to ask that the court had appealed rather that he should calm down severally, that there's decorum in the court and the court will maintain decorum. There's a process to these things. He had the matter of fact that he had 3 applications and challenging the court to take to the Court of Appeal for interpretation and answer, and also that he be granted bail. He moved the application, and the court, as a matter of fact, asked the prosecution counsel to respond. The prosecution counsel insisted that these issues raised in these 3 new applications had already been raised previously during the process of the trial, and asked the court to dismiss the application. Justice Omotosho ruled on the application and said that the court is not here to collect evidence, but to give judgment. And to the issue of bail, that there is a subsisting bail application that was first filed by Mr. Kanu. So it's like though the bail application became an abuse of court processes. So the court has said that he had earlier given an order that it will take both preliminary objection and the substantive matter when delivering judgment. And that was how the court went into delivering judgments today.
There were 7 counts, and the court has convicted the defendants now of, 1, 2, 7 of these charges. Walk us through the charges and some of the incidences that were, cited in this judgment.
Okay, let's put on record that from the first count to the 7th count, he was found guilty, and these counts carry different sentences. Counts 1, 2, 4, 5, and 6, as a matter of fact, carries death sentence. But counts 3 and 7, count 3 carries 20 years imprisonment as so as count 7. Count 1 was inciting violence. The court, as a matter of fact, saw the evidence tendered by the prosecution, and because Mr. Kanu did not enter his defense and did not file a final written address, and in criminal proceedings, when the defendant do not find his or her final written address or do not enter his or her defense, it's deemed that the defendant is relying on the case of the prosecution. So that was what happened today. And in count 1, it's life sentence, death sentence, I beg your pardon, because the court found out that through the evidence tendered, Mr. Kanu indeed incited violence when he called for the fact that people, citizens in Nigeria from the southern eastern part of the country are being killed. They should take up arms and all of that. And also during the course of the NSAS protest, he made a broadcast through Biafran radio where he called for police officers and their families to be killed, buildings belonging to the federal government should be bombed down. And also another instance, he also called that chemistry students and students of chemical engineering should go and start creating mocktail bombs. So all of these evidences were tendered in courts. They were played. All these broadcasts were played. So what the backing of the court today to deliver its verdicts by convicting Mr. Kanu is because he did not enter his defense, or he did not, as a matter of fact, deny this claim through final written address. Although he had filed a no-case submission during the course of the proceeding where the prosecution had closed their case, the court dismissed that no-case submission and said that he should enter his defense. Not because he was guilty at that time, because the court found out that there are some questions he needs to answer in respect of the charges. But he had insisted that the prosecution did not establish any prima facie case against him, and the court did not agree with him and asked that he enter his defense. And the court, after asking Mr. Kanu to enter his defense, adjourned for over 6 times, insisting on him to enter his defense, making it clear to him and also for him to file his final written address. But today, before the judgment was given, Mr. Kanu was asking for time to file his final written address. And the court said, we had given you enough time. We're giving you ample time for you to file your final written address, but you refused to do so. So these were the issues that happened in court today. And the prosecution counsel is asking that the court hands down the maximum sentence so that this will serve as a deterrent to anyone who wants to incite terrorism, whatever form. And the court also rightly mentioned that self-determination is a political right, as captured as in the African Charter of Human and People's Rights, but also it should be in line with our constitution. It should not contravene our constitution. And by the time it contravenes our constitution, it is a problem. And the court said today that it can only be gotten through the amendment of the constitution, not referendum. So anyone who wants self-determination or wants to break away from Nigeria should go to the National Assembly to seek amendment of the constitution.
All right, Celestina, we expect the court to reconvene. We don't have so much time, but before I let you go back into the court, the court is expected to reconvene. What should we be expecting to see? What's your expectations? Well, we don't know what sentence the court will give. If the court will go by the plea of the prosecution to hand down the maximum sentence, which is death sentence, or the court will listen to their locutors, which is a plea made by the House of Representative member from the constituency that Nnamdi came from. Though he had pleaded for leniency and asked the court to temper justice with mercy. So we don't know if Justice Omotosho would hand down the maximum sentence or would temper justice with mercy and be lenient in his sentence. And whichever way, because the judgment, the sentencing goes, the prosecution will ask that Mr. Kanu be kept in the safest place if he's been remanded or convicted, whichever way it may go. Because according to him, Kuje Correctional Center is not really safe because of the previous jailbreaks that we've had in Kuje. So we don't know where else Mr. Kanu will be sent if indeed he's found guilty, or if he's found already has been found guilty, and where the court will send him, if it's where he will be sentenced to death, because we only have 8 gallows in all our correctional centers in Nigeria. So it will be within those prisons and correctional centers that have these 8 gallows. Thank you, Celestina, for that update. This, pretty much sums up what we have seen. We have been monitoring generally live in court. Thank you for joining us at this time. That's our senior reporter live for us at the Federal High Court in Abuja, who has been monitoring Nnamdi Kanu's judgment.